All right, next up is Paul Madison Phillips. It's case number 2613-712. This case is set for a Cobb's hearing. The offer that was tendered was a plea to a 10-year felony offense of breaking and entering the building with intent, reduced the habitual offender fourth to habitual offender second. The plea within the advisory guidelines, the prosecution's estimate of the advisory guideline would be 19 to 47 months. The defense requested the opportunity to submit a Cobb's memorandum, which I've read. People have responded. And you can go ahead, Mr. Price.
Thank you, Judge. Judge, he has a pending case in Oceana County. He is scheduled for sentencing there on March 23rd. It seems that the sentence there is going to be a 19-month sentence to the Department of Corrections. So we're asking the court, he's got a 19-month cap there, his guidelines for 19 to 38. So we're asking the court to provide the same sentence here. We're asking for a sentence at a 19-month time would then run concurrent with his time in Oceana County. And also point out for the court that since he is on parole, he has no good time credit, so he's sitting on dead time, Judge. So the actual, if he's given 19 months, would probably be considerably more since he's been in jail for some time now. So didn't have any violations for 90 days while he was on parole. Committed this, he had an arrest for this offense. We have already provided the court with our notice and intention to enter a no contest plea. We were going to do that the last time, and there was some questions about what kind of sentence the court would give. So that's why we're here today with the Cobb's memorandum. So we're just asking that the court follow the plea recommendation. It is sentenced within guidelines. We're just asking the court to sentence him to the minimum on the guidelines, which, as I say, would then be concurrent with Oceana County. And possibly, if we come to an agreement today, they could, since they're doing the PSI in Oceana County, I know it's kind of early, but he is scheduled there for March 23rd. So possible if we could get this sentence done at the same time, Judge. Thank you.
Right. And the charge that your client's on parole for would be a possession of methamphetamine. Is that right?
No. Yeah, it's a UDAA, Judge. He's on parole for the UDAA charge, which I think was
I don't see a UDAA listed on the people's recitation of his criminal history.
So 2023, Oceana County.
he's pretty sure, Judge, it was UDAA. It might not be showing on the criminal history, but it was in Oceana County. It's on parole.
All right. Okay, thank you, sir. And Ms. Robinson, read your memorandum as well. Any additional arguments that you want to make?
No, Your Honor. I think it is well laid out in the, I think the court has an idea of where we stand on this. I know I put in there, but I do want to put on the record so that Mr. Phillips is aware that we did notify the court. We did look into that conviction from Mason County that he said he couldn't possibly have had because he was in prison. We called the court multiple times. We finally were able to get someone to just tell us they have no record of that ever being a thing. I don't know why that's on his CCH, but it does not appear that that conviction exists. That does not change anything because he was maxed out on the PRVs anyway. According to the MDOC website, he is currently on parole for a breaking and entering a building with intent out of Oceana County. So it's not a UDA, it's a B&E with intent. From all the information that we have, I would ask the court to sentence him within guidelines. I believe that a sentence closer to 30 months would be more appropriate. I understand he got 19 months in another county, or that's what he's looking at, but this is a different crime. And the idea that, you know, he can commit as many crimes as he wants while out on parole, and he should just have the same sentence and not have additional time, I don't think is appropriate, especially based on his record. So I would ask the court to take all of that into consideration and sentence him within guidelines. Thank you, Your Honor.
All right. So the court would enter into a covenant agreement not to exceed the advisory guidelines, which would be a sentence consistent with the advisory guidelines if the prosecution actually accurately scored the advisory guidelines. They would reflect a sentence between 19 and 47 months. The actual scoring may be different. It may be higher or lower than that, but the court would agree not to exceed the advisory guidelines as I scored them at the time of sentencing. I don't think Mr. Phillips, the sentence on the low end of the advisory guidelines is appropriate in this case. The record indicates that you have 4 prior misdemeanor thefts. You have 4 prior felony thefts, and 3 of those prior felony thefts were breaking and entering with intent. So this is the 4th time around, allegedly in this case. And but for this agreement that you said it's consistent with the advisory guidelines, you would be a perfect candidate, in my opinion, to exceed the advisory guidelines because you are a career thief. So I'll agree to stay within the advisory guidelines as I score them at the time of sentence.
Okay. So we're looking at no cap, just a 19 to 47 without a cap at this point.
And he's going to be on the high end of that. I'm not going to say it's going to be 47 or whatever, but he's going to be on the high end of that.
We're open for like a 30-month cap.
Not at this point. I wouldn't commit to that.
So, you want to go ahead and get here, 30, 36. It's not going to do that.
Judge, we've already provided the court with a sign that twice a week, sir. We provided the court with a no contest plea on February 2nd, 2026. The court should have that in the file, and it is his intention at this point in time to go ahead and enter that plea, Judge.
Okay. Is that what you want to do today, Mr. Phillips?
Sure.
All right. Raise your right hand, please, sir. You solemnly swear, oath, or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yep.
All right. So the charge that you're entering a no contest plea to reads as follows: that on or about November 4th, 2025, that you were in Everett Township, Nuevo County, State of Michigan, and that you committed the crime of breaking and entering a building with intent. That you did break and enter a shop located at 620 Evergreen with the intent to commit larceny therein, contrary to MCL 750110. This is a felony which carries up to 10 years in prison. Do you understand count 1 and the maximum penalty?
Yes.
You're offering to reduce the habitual offender 4th to habitual offender 2nd, which means you have at least 1 prior felony conviction. Do you understand that?
Yeah.
What they've listed here was it on or about January 22nd, 2024, that you were convicted of the felony offense possession of methamphetamine in the 51st Circuit Court for Oceana County? Do you have that prior felony conviction, sir?
Yes.
With that prior felony conviction, that carries the possibility of increasing the maximum penalty in this case from 10 years to 15 years. Do you understand how habitual offender second could
Yes.
increase your maximum penalty?
Yep.
So you have plea agreement in this case that you be sentenced consistent with the advisory guidelines and no new charges. Do you understand that?
Yeah.
All right. And at this point, the court is agreeing to go along with the sentence within the advisory guidelines. Do you understand that? The prosecutor has provided an estimate of 19 to 47. Your actual guidelines at the time of sentencing could be higher than that, or they could be lower than that. Do you understand that? And because you are on parole, this is going to be consecutive to your parole. Do you understand that?
Yes.
That means that any time that you spent in jail so far would accrue towards the case that you're on parole for, that you would get no credit on this offense until your sentencing starts. Do you understand?
Yes.
Okay. All right, is that your complete understanding of the agreement in this case, including the plea agreement and the COPS agreement?
Yeah.
You had sufficient time to consult with Mr. Prysock about your charges and this plea agreement. Subject to the plea agreement, how do you wish to plead?
No contest. Same thing.
So did you want to plead guilty or no contest?
No contest.
And that's for civil liability, Mr. Prysock?
Yes, Judge, there's some losses here that I believe you'd be subject to a civil lawsuit.
All right. And Mr. Phillips, do you understand with the no contest plea, you're not admitting this charge, but you're no longer denying it? The court's been provided a copy of at least portions of the police report, and if I find that the elements of the offense are contained therein, I would find you guilty. You understand that? You would be convicted of this offense. Do you understand that? It'd be on your record and you'd be subject to sentencing. Do you understand that?
Yes.
You also understand that if I accept your no contest plea, you're giving up the right to have a trial of any kind.
Yes.
You've been provided other rights that you're giving up in writing. Did you read that document?
Yes.
Did you understand those rights?
Yes.
When you signed it today, is that correct?
Yes.
Specifically, the rights that you're giving up by entering this no contest plea are the right to be tried by a jury. You understand that?
Yes.
To be presumed innocent until proved guilty. To have the prosecutor prove beyond a reasonable doubt that you are guilty.
Yes.
To have the witnesses against you appear at the trial. Understand that, sir?
Yes.
You're giving up the right to question the witnesses that the people would call against you. Do you understand that?
Yes.
You're giving up the right to have the court order any witnesses that you have for the defense to appear at the trial. Do you understand that?
Yes.
You're giving up the right to remain silent during the trial. Do you understand that? You're giving up the right to not have that silence used against you. Do you understand that? And you're giving up the right to testify at trial only if you want to testify. You understand that? Is that a yes?
Yes.
Okay. Further, if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial. You understand that?
Yes.
And further, any appeal from your conviction and sentence pursuant to this plea will be by application for you to appeal. It's not an appeal by right. Has anyone threatened you to get you to make this plea?
No.
Has anyone promised you an outcome different than what we put on the record?
No.
You're entering this plea of your own free will.
Yes.
You understand that if I accept your no contest plea, I'm giving up the right to later claim that this plea was not your choice.
Yes.
do not give up your right to have trial of any kind and all the rights that you would have at that trial? And do you still want to plead no contest?
Yes.
And Ms. Robinson, any objection if the court reviews the report to see if there's a sufficient factual basis?
No, Your Honor, I believe that's appropriate.
All right, so the court has had an opportunity to review the report, and what it indicates is that an individual broke into a Bam Buys pawn shop, that the individual was caught on video surveillance cameras. Not only that, the owner of the pawn shop thought she recognized the defendant as someone who had been into the shop before and had previously sold her items that had been stolen. She remembered his name and thought she knew where he was staying. Authorities then went to the defendant's room at Johnny's Motel, found evidence of items stolen from the pawn shop there. In that case, it was an iPod with a for sale sign of $80 on it that was found in the defendant's room. They then pulled the surveillance footage from Johnny's Motel, which showed the defendant leaving his room there at 12:48 a.m. The break-in at the pawn shop was about 1 a.m. And the video showed that the defendant was wearing, the video of the defendant leaving the motel showed the same clothing that was worn by the person that broke into the pawn shop. The footage then showed the defendant returning to his room at 1:57 a.m., no longer wearing the Nike hoodie. The hoodie and was found on the railroad tracks behind the Johnny's Motel where the defendant was residing. So based upon that, the court does find that the information provided does support the factual elements of this offense. I guess the other thing that the video showed was that somebody broke into the back door of the pawn shop holding something that looked like a screwdriver, so it was a forced entry. The defendant has previously indicated that he does have at least one prior felony conviction. Are the attorneys aware of any promises, threats, or inducements which have not been stated on the record?
No, Your Honor.
There are none.
Is he competent to enter this plea?
As far as the people are aware, Your Honor.
He is.
Does the court comply with MCR 61302?
Court has, Your Honor.
The court has.
All right. The court court finds the plea to be knowing, understanding, voluntary, and accurate, I'm going to set sentencing for April 7th at 9:00.
There's potentially a significant amount of restitution. Would you like to have a hearing if we need one at the same time or at a later date? It looks like it's approximately $23,000.
How much?
23,000.
Yeah, we'll probably have to set that for a different time.
Okay.
I mean, as part of the no contest plea, there was, I don't know if it was the full list of items that were believed to be stolen with approximate values. The court was just kind of interested in some of the things that were alleged to be stolen. And certainly I'm no expert in the value of coins and collectible dollars, but a quick search of the internet didn't support those values. So I'd be interested in testimony that would establish the values of those items. So
I understand, Your Honor. I just saw it was a very significant amount and wanted to bring it to the court's attention.
yeah, well, and there's, yeah. So it's, I understand that. I think it's going to probably take some time if the defendant chooses to challenge the value of those items. It's going to take some time to sort that out.
Absolutely. I just didn't want to spring it on anyone. I will get the information I have to Mr. Price.
And we'll set a different date for the restitution.
Thank you, Your Honor.
All right, Mr. Zerko, okay. April,
The courtroom proceedings in case 26137112 present a classic example of how prior criminal history can heavily influence judicial discretion. Paul Madison Phillips did not walk into court as a first-time offender hoping for leniency. Instead, he stood before the judge with a documented pattern of theft-related crimes, multiple misdemeanor thefts, multiple felony thefts, and prior breaking and entering convictions. That history shaped the tone of the hearing from the outset. What made this case particularly compelling was the strength of the evidence. Surveillance footage from the pawn shop captured the break-in. The shop owner recognized Phillips as someone who had previously sold her stolen items. Police then discovered stolen property in his motel room. Additional surveillance connected his movements precisely to the time of the crime, even discarded clothing tied back to him. The timeline was methodical, layered, and difficult to dispute. When Phillips entered a no-contest plea, it was less about admitting guilt and more about accepting the weight of the evidence and limiting potential exposure. However, because he was already on parole, the sentence would run consecutive to his existing obligation, eliminating the possibility of concurrent time and increasing real consequences. The judge's remarks were blunt but revealing. Referring to Phillips as a career thief, the court signaled frustration with repeated criminal conduct despite prior opportunities for reform. The advisory guidelines offered a range, but the court made clear that the low end would not be appropriate. Now, the case moves toward sentencing with a potential $23,000 restitution hearing still pending. The final chapter will determine not only how long Phillips serves, but whether financial accountability further underscores the seriousness of the offense. In the end, this was not just about one break-in. It was about pattern, accountability, and the diminishing patience of the justice system.